So we looked at the law. When I speak to lawyers, there's like 30 slides on the law. I will have 2, so just relax. There's not going to be a lot of slides. The big thing is there were all these cases. The Supreme Court had kind of indicated that they thought excessive partisan gerrymandering, excessive rigging of the maps to benefit a political party was unconstitutional, but they couldn't find a test. They couldn't figure out how to measure it and when it was too much. So they said, well, we think it's a problem, but we're not going to overturn any maps on this basis. And so over the course of 3 decades, people had tried. But in 2004, Justice Kennedy issued an invitation in the course of, I lied, no, I didn't lie, there's only 2 slides on the wall. I took the last one out. So here's what he said: I would not foreclose all possibility of judicial relief if some limited and precise rationale were found to correct an established constitutional violation, that a workable standard for measuring a gerrymander's burden on representational rights has not yet emerged, doesn't mean that none will emerge in the future. So this coded language, a workable standard has not yet emerged, but one might. Well, when a Supreme Court justice says that, he's issuing an invitation. He's saying, bring me a workable standard, right? So this group of citizens, Fred Kessler and James Hall and Peter Earle and me and Bill Whitford, who's a retired law professor from Madison, connected with a law professor at the University of Chicago, Nicholas Stephanopoulos. He came up to Wisconsin to a meeting, and he said, I've got a standard. I have the test that answers the call in Veith. And it's based on a metric called the efficiency gap. It's a mathematical test. And you have the facts on the ground and the ability to organize people in Wisconsin. Let's marry those 2 things together. And over the course of a year, then, because this efficiency gap was a measure of partisan symmetry. That's the thing you get. We're trying to measure that thing we were talking about earlier. We were able to pull together experts and plaintiffs and lawyers and recruit people and raise money, and we filed a case. So now another election has passed. The 2014 election had passed. And all of our understanding of how rigged the maps were was confirmed. Because the Republicans won a huge victory, but they didn't get that many more seats. Right? They got basically the same. They got 3 more seats, but they got a huge swing in the vote, right? So we saw that was stable. And we hired these experts, we filed the case in federal court, and this was in July of 2015. And then we had to, I'm going to come to this in a second, then we had to overcome a motion to dismiss from the state. Again, no case had overcome a motion to dismiss in 30 years. And we won that 3-0. It was a 3-judge panel, we won 3-0. Then we had to overcome a summary judgment motion, and we won that 3-0. And in May of 2016, about 10 months after we filed the case, almost 11 months, we went to trial, and there was a trial. And then 6 months later, well, I'm going to get to that in a second. So we asked for a test, this 3-part test, it was documentally incremental. Let me tell you what the test was. I got to know what order my slides is. So what we wanted in the test was we wanted to say we had to prove partisan intent, we had to prove partisan effect, and we had to ensure that the map was not justifiable on other grounds. The reason this is important is because we weren't just saying measure the map. We were saying make us prove it. And this is the same process that's used to determine if a map is racially gerrymandered to an over, not in a voting rights way, but to actually disenfranchise people of color. So we based on that test, and I gotta see what slide I got here. And what had happened a few years earlier is there had been a case, I mentioned this lawyer, Peter Earle, and he'd helped prosecute a case in which they challenged the map on a bunch of different grounds, and they didn't make a lot of progress. They won, but they just changed like the one line between these 2 districts. There's these 2 districts right here in Milwaukee, and there was one line between them, and they just moved the line a little bit. But in the process of prosecuting that case, there was a lot of discovery, right? There was a lot of information that was unearthed that the Republicans who had drawn the maps didn't want to be public. And when they drew these maps, they drew them very quickly, much quicker than normal, and they drew them in a secret map room, and they used a really kind of corrupt process. It's been talked a lot about in public, because there was these recall elections happening. Remember the controversy over Act 10? And what they were afraid was going to happen in the summer of 2011 is they were going to lose control of one house of the legislature, the Senate. And the math was that they might lose, right? So they pounded these maps through as fast as they could. And they didn't make public all the criteria and all the data that they used. They didn't actually lose control in 2011, but they did lose control in 2012. And when they lost control in 2012, it turned out that, well, now the Democrats were in charge of the Senate just for a few months, and they were the clients of the lawyers who had helped draw the maps. So they said, well, give us all the files. Give us the files. And they hadn't wanted to turn these files over. So the lawyers were running around. They were from a law firm, big law firm in Wisconsin, and they said, we don't want to turn over. Well, we're just going to turn over the same files that we've already turned over in the federal trial discovery. We're not going to give them anything new. Except they had, I don't know if they had someone honest working there or they just made a mistake. They turned over 34 documents. And there were tens of thousands of documents. But there were 34 documents that hadn't previously been disclosed. And so when the lawyers figured out, wow, there's these 34 documents, what else is out there? And then there was a bunch more litigation that went back and forth. And at the end of the process, the federal court was really, really mad at the Republicans. They were really, really mad at the law firm. They fined them a bunch of money, and they said, you have to turn over the hard drives. We're not going to rely on you to pull the documents down and give them over. We want you to actually take the hard drives out of the computers and hand them over. And one of the hard drives had been smashed with a hammer, but there were mirror copies, and so out of these 9 hard drives that existed, 8 of them got turned over. And when they went to these hard, they found more documents and more documents and more documents. And one of the documents that they found, which eventually, as they were going up to trial in our case, in the Whitford case, they said, what does the spreadsheets tell us in all this data that, and they went back and they were like, well, we got to figure out what we can find. And they found these spreadsheets, and the Republicans started with the 2000s map, the map from the 10 years prior. And under that map, there was like a baseline of 49 Republican seats. So they started tweaking the map to make it more Republican. They got it up to 52 seats, they got it up to 56 seats, 57 seats, 58 seats. And the names of the files, they started with 2000s map, Joe Base Map Basic, Joe Base Map Assertive, Joe was the guy drawing the maps. TAD, Make You an ID, Joe Assertive, TAD Aggressive 1, TAD Aggressive 2. So they literally had the names of the maps as they got more assertive and more aggressive. And they got the map up to 59 seats from 49 seats. This was the baseline Republican allocation of seats. And then they kept tweaking it. See how this line got flat? But what they did is they kept it at 59, but they made the 59 stronger and stronger and stronger. And what they were testing here, they used something called a swing analysis. They actually tested if the election went more and more Democratic, can we keep the map impervious to those election results? They actually tested that. They didn't say, well, let's make the map fair because we want, Beloit to have a seat, we want Nina and Menashe to be together, and we want it to be equal population. They tested the map to say, can we make the election not meaningful? And then they had to turn the spreadsheets over because the federal court made them turn the hard drives. They actually didn't turn the spreadsheets over, right? They were on the hard drives. They'd never released any of this stuff in discovery. We found the documents. Guess what? We proved partisan intent, right, at this trial because they had the partisan intent. We proved partisan effect. This is the same as this chart over here. We had an expert measure 800 redistricting plans in modern American history. 50 years worth of plans, over 40 states with publicly available data. By one measure, Wisconsin was the 4th most partisan map. By another measure, Wisconsin was the most partisan map in modern American history. So we showed that there was an effect, right? The justices said, it achieved the intended effect, it secured for Republicans a lasting assembly majority. That's what the judge who wrote the decision. The judge was appointed, by the way, he's a conservative Notre Dame law professor on senior status, and he was appointed by President Reagan to the federal bench. That's who wrote this decision. And then we showed with our experts and with data that you could draw a fair map. Remember those maps that Nancy showed you at the beginning? The colors, it's hard to tell because there's more rural counties on kind of thing, but basically this was the unfair map, and we showed that if you drew the map fairly, you would have a lot more blue seats. And there was no justifiability for what they'd done other than partisan intent, right? And so after this trial, we had to wait 6 months. In fact, there was yet another election. Now there's been 2 elections since we filed the case. There was the 2016 election. And in November, 2 weeks after the election, we got a decision. Skip that here. And we won. We won. The maps were declared unconstitutional because they had rigged them to make elections not meaningful. Are you stunned into silence? Or are you just not care? So this is a big moment. We actually won a federal trial. This had not happened ever before. Yay, that's right. Sometimes I get applause there. I don't know what. Sorry. The court issued a really clear ruling that the maps were unconstitutional. They were intended to burden the representatives